Thank you very much also for inviting me again to the Asma Jahangir conference, and I'm very, very sorry that I wasn't able to be there in person this time. But I also still look forward to today's session and this conversation. First of all, let me say that I think the child custody issue and the instrumentalization of what we call parental alienation is a very good illustration of the topic of your session, which is the legislative constraint and judicial violence that women face. And I will speak to why that is the case. First of all, because the way in which family courts deal with child custody issues today in many countries is an illustration of the inadequacy of how legal systems deal with domestic violence in general, both as a form of violence against women, but also as a form of violence against children. We know that domestic violence is one of the most egregious and pervasive human rights violations that women face. We know it's highly gendered, which means that while men can also fall victims to domestic violence, the facts on the ground show that women are at a much higher risk of the dynamics of abuse and in the family, and that these dynamics are very, very different for them and affect them differently. And we know that most of the victims of intimate partner violence are women. We also know that most women killed are killed by their partners or somebody they know, and that prior to being killed, there is a history of violence that leads to this killing or to this femicide. We also know that most women that are subjected to violence and abuse tend not to report these incidents. And of course, the causes of domestic violence are complex, but at the heart of it is gender inequality and the unequal distribution of power between men and women in society, but also in the family. So when women victims of violence finally muster the courage to report on the domestic violence they are experiencing, they run into another set of challenges that renders them unassisted and unprotected, often with catastrophic consequences in which they will end up further harmed and killed. That is because the allegations of domestic violence they come forward with usually receive insufficient scrutiny by courts. There's often the assumption that they are not serious enough, and that also plays out in family courts once the mother and the father of a child has separated. Once they have separated and the mother alleges incidents of domestic violence or abuse against her or the child, courts usually will take the attitude that because they are separated, therefore that violence has stopped, or because they have separated, it doesn't matter so much anymore. It has no implications on the child or on the woman because she is physically not anymore in the same space as the former partner. And then you have the issue that often courts actually disregard the importance of domestic violence altogether when it comes to child custody cases. They consider it simply as irrelevant. The other thing is that child custody issues, including the instrumentalization of parental alienation, illustrate very well how much there is a gender bias in courts in general, but specifically also in family courts. So I have found through this research and through conversations with women organizations and with victims and countless mothers around the globe that there is sort of an inclination to underestimate and to underestimate the extent to which gender stereotyping and patriarchal attitudes influence custody process, and therefore result in the failure of justice. So it's not uncommon, therefore, for both law enforcement and justice systems with which mother and child come in contact to have deeply embedded biases. And the gender bias is strengthened by the gender discriminatory laws that exist in some countries, which, as we know, are motivated by cultural, religious, and social factors. And this gender bias colors how judges, police officers, social workers, psychologists, and others tend to hear, understand, perceive, and react to women that come in contact with them, including victims of violence. And therefore, it can result in a massive miscarriage of justice. And these biases can be particularly highlighted when a woman comes from certain racial, ethnic, or religious backgrounds. And for example, if she belongs to a religious minority, or if the woman is a migrant, or, for example, based on her sexual orientation. And what happens, one example of this gender bias is that in custody courts, judges tend to view mothers as inadequate mothers, unable to protect and take care of their children, especially, for example, if they are migrant women, and therefore this perception comes into play. Another gender bias on intersecting ground is, for example, that in some countries, educated women are not seen to fit the mainstream image of a domestic violence victim. So if she's successful in her career, if she's highly educated, but she claims that she has undergone abuse or domestic violence, that gets to be disregarded because it doesn't fit with the image that they have of what a successful, independent woman is. And these kind of biases are then compounded in the case of child custody issues. And we know, of course, that according to international law, states have an obligation to ensure that gender stereotyping is addressed and dealt with adequately. For example, through the Convention on the Elimination of All Forms of Discrimination. So then how does parental alienation accusations fit into this, and how are they really an example of the persistence of domestic violence and gender bias? Well, we know that in recent decades, there is this concept of parental alienation, also called parental alienation syndrome, that's been widely used by courts when assessing child custody cases, especially when a child expresses fear or avoidance of a parent. So despite the lack of credible scientific support and the fact that the World Health Organization had excluded this from its classification index, it continues to be explicitly referred to by justice systems worldwide. So according to this pseudo-theory that has been disregarded and discounted by the World Health Organization and others, a so-called alienated child would be manipulated by one parent to turn against the other and resist contact with that parent, usually during child custody disputes and in connection to divorce proceedings. So among the symptoms of this alleged syndrome, the child would display relentless denigration of the targeted parent, refuse to have contact with the extended family or the target parent, and insist that they are expressing their own opinions and not those of the alienating parent. Now, while this pseudo-theory is theoretically gender neutral, what we have found is that it's most frequently applied against the mothers, especially when they claim that they have been abused by the father, or when they claim that the father has abused the child. So what happens is that when in courts, a mother comes forward saying, I've been abused by the father of my child, or worse, the child has been abused by the father, or there are sexual abuses happening against the child, the father and his lawyers, or even the justice system, will come back and accuse the mother of alienating the child. And they will then also perceive or represent the mother as less credible than the father, and reframing the allegations as attempts to hinder or block the contact between the father and the child. So we have seen that courts will support the father's also right to having contact with the child and punish the mother either through loss of custody or imprisonment for this supposed interference. So they will disregard almost immediately allegations of sexual or domestic abuse against the mother or the child and claim that it is made up and that the mother has invented this in order to alienate the child from the father. Now, what's also concerning in all of this is that the child is rarely asked about what has happened. The voice of the child is rarely factored in. Children are not consulted in a child-friendly manner. And so the children are not listened to during court proceedings, and it becomes a really big issue. So this is with regards to parental alienation, and I'm happy to answer any questions. Now, on the issue of self-ID, if you allow me, Nida, I'll just be very quick on this and happy to answer also any questions. So I do recognize that according to international human rights law, states do have an obligation to facilitate the legal recognition of gender diverse people in a way that is consistent with equal protection before the law, privacy, freedom of expression, and freedom from discrimination. However, having said that, there is really no right in international human rights law to self-identification of gender identity. And even UN agencies who claim that there is have not been able to substantiate this argument. And in fact, I would say, and I have said in the past, that this claim that there is a human right to self-ID is also not supported by state practice. Currently, we have around maybe 25 states that have self-ID of gender identity. That's around maybe 15% at most of states. So there is really no international recognition that this self-ID, that the right to self-ID exists. Now, self-ID has also been put forward through a document called the Yogi Carta Principles. This is, however, a declaration made by experts or activists that came together. But again, it's not sprung out of a interstate process. No states have signed up to it, and in fact, one of the members of the Yogi Carta Declaration has also withdrawn from it because he considered that it has insufficiently considered the impact on the rights of women. The way self-ID legislations are being pushed through parliaments in the world have also ignored women organizations' views, have insufficiently consulted with them. And what's the most troubling about self-ID laws, in my view, and in the view of many other human rights experts, is that they have no safeguards built into them, meaning that because they allow any male to self-ID as a woman, that means that it can also allow males that have had a history of violence against women to do so. But also it allows, it prevents safeguarding in the sense that any male is allowed then to enter into any female-only spaces, and that we have seen this being problematic for women in prisons, for female sports, and also for services targeting female victims of violence that are, through these laws, asked to reframe their trauma and to be in spaces with males when they have really suffered horrendous abuse at the hands of males and therefore need female-only spaces. We have also seen how allowing self-ID for children can be very problematic because it can also result in fast-tracking not just social transition of children, but also into then medical transition without adequately taking into consideration whether what is at stake here is really gender dysphoria or whether there are other psychological issues at play. And therefore, it has prevented also a proper inquiry into the well-being of the child to see what is it really that the child needs. Is it gender-affirming care, or is it something else? It also, and I will stop here, the biggest problem with self-ID is that if anyone can be then a woman and anyone can be a man, it also leads to the mischaracterization of the phenomenon of violence against women, which is primarily a situation of male violence against predominantly females. So when now male perpetrators of violence are registered as women, then that leads to really a confusion about what we are talking about, and therefore a confusion about what is needed. So when media refer to somebody as a, who has killed a woman, their wife as a woman killing a woman, that stops being violence against women situation, that stops being a femicide issue. And it can also potentially exonerate then male perpetrators of violence once they have identified as women from being pursued under the justice system, because in many laws, violence against women or femicide is identified as male violence. So I will stop here, and I'm sorry if I took too much time.